Good day to Dr. Asma. My name is Chong Wen Ni, Matric Number 270799. In this video, I will talk about the preparation in mooting. Preparation in mooting tends to be the most time-consuming part of mooting. You will need to ensure that you thoroughly read the fact pattern, understand exactly what you are expected to argue, and being assimilating your relevant authorities for discussion. There are a total of 5 steps in the process of mooting. Step 1. Read the moot problems and identify the issues. Before the moot starts, you will be given the moot problem. Identify the issues and problems from the moot problem in order to tackle the problem efficiently. It is the most important element in mooting. Creating a chronology is one method that can aid a mooter in completely understanding the moot problem. The chronology is designed to briefly document the facts or events as well as the questions to be investigated. We need to adhere to some important procedures to identify the issues from moot problem efficiently. Read the moot problem carefully several times and do the analysis of the case. Some of the moot problems require critical thinking. Thus, it is vital to read the problem several times. Failure to identify the issues will open the door for the opponent parties to win the case. Step 2. Do the basic research. Before framing the allegations and contention, it is vital to carry out basic research to ascertain the material available for the moot problem. Try to search judicial precedent with the same facts and find the judgment and laws to support the arguments under every issue raised. Ascertain the keywords to determine the points of research, to frame skeletal contentions or issues to be tried. When conducting research on applicable laws, it is essential to understand the aim and function of the law. The mooter should seek to understand the purpose of the law and the sphere of application. After reading and understanding the law, the mooter is to apply the law to the facts of the moot problem. When researching case law, it is crucial to determine how the case will be applied to the facts, whether the case is required as precedent to explain the law or only as persuasive authority. The mooter must ensure that the case fundamental contention is still valid when conducting case research and keep current cases that are relevant to the topic in mind. To succeed in the moot, the mooter should use cases to support both sides of the issues in question and should create one-page summaries of the key cases for ease of reference. Step 3. Set a timeline in which the submission shall be done in a specified period. The timeline as specified is to prevent the postponement of the submission and drag the case. It is vital to set a timeline because a lawyer needs to provide a reasonable reason to request for adjournment of the case. In the event that a lawyer is unable to file the submission within the allocated time due to health-related issues or any other unavoidable emergencies, he may request from the court for an extension of time to file the documents. Step 4. Make a flowchart. It is pertinent to create a flowchart as it is easy to understand and catch up with the important elements. The important elements such as the relationship between the plaintiff and defendant, the allegation of both parties, the issues and legislation, and simplifying the moot problem to understand it in a better way. Step 5. Discussion. A prior discussion is required between the counsels. The teammates shall have similar facts in their knowledge because the court will not allow discussion between lawyers during the proceeding. Everyone has different perceptions in terms of the issue raised and the principle of law. Thus, the discussion will ease the ascertainment of the moot problem. Moreover, a good set of written submissions will present its arguments clearly. Before a moot takes place, you will usually be required to submit a skeleton argument. It is very important that your skeleton is as concise as possible, accurate, and covers all and only the main points of your argument. A properly drafted skeleton argument for a hearing contains a number of items. They include an introduction, a list of issues, a case summary, a summary of the arguments, and a conclusion. You should therefore be able to demonstrate that you can read your instructions and follow them to the letter. This also helps to create a good impression and show that you have really thought about what you are doing. Memorandum of submission. In preparing for the memorial, must be taken note that the memorial acts as a legal written document, which forms your framework for oral pleadings. It will have common sections such as a statement of jurisdiction, a statement of facts, a summary of arguments, pleadings, and authorities, and of course not to forget the prayers. While writing the memorial, the mooter is to deal with the issues one by explaining the facts and then applying the law or the policy to the facts. Remember, your memorial should be persuasive while leading cases as a foundation. Allocate sufficient time and dedication to do research, gather legal precedents of the highest court, followed by a higher court, as well as citations of relevant legal sources.